In this video, I'm going to be talking about expungement in Indiana. A lot of people may not know that you can actually clear your criminal record. This video talks a little bit about how you can go about clearing or sealing your criminal record, as well as the different qualifications and process to do so. So about me, my name's Nathan Vining. I'm a criminal defense attorney here in Indianapolis. I represent people in expungements across the state of Indiana, and I can help answer your questions about expungement. You're going to be having job application issues. You could be dealing with your criminal history in a child custody case and want to do something to remove this record from your history. Just privacy concerns if you are looking to meet new people and you don't want people to find out about your criminal record or something that you did when you were much younger and you're a different person now. There could also be issues with professional licensing where you need to have records expunged so that you can get a license. You can also obtain access to your gun rights again. And also you can just remove bad information about you online through an expungement. What it does is shows you that an Indiana expungement allows you to move past your criminal record so that this can't be used against you in your future. So the next thing to talk about is expungement eligibility. So expunging arrest records is first. And you may need this kind of an expungement if you were arrested, you were taken to court, and you entered into a pretrial diversion agreement, or even if the case was dismissed, the arrest records are still out there. So you would want to expunge the arrest records. And it's important to know that you actually have to wait a year from the arrest to do so. So the requirements for an expungement of arrest records is set out in 35-38-9-1. And the requirements are that the arrest didn't result in a conviction, you're not currently participating in a pretrial diversion program, and 1 year has passed since the arrest. If you meet those requirements, you should be able to expunge those arrest records so that way they can't be found and can't be used against you. The next thing to talk about is expunging misdemeanor convictions, and that's 35-38-9-2. And the general requirements for a misdemeanor expungement are that 5 years have passed since the date of conviction, you have no criminal charges pending, you've paid all fines, fees, and court costs, and you haven't been convicted of another crime within 5 years. If those requirements are met, you could qualify for a misdemeanor expungement, and then you would get all of these benefits that are set out in section 10B, that would allow you to move forward from that conviction that's on your record. So again, it's just basically those four requirements. If you meet those, you should be able to expunge a misdemeanor conviction here in Indiana. The next level is expunging D felonies and level 6 felonies. The Indiana felony system, D and level 6 are the lowest, and D felonies are what they used to be classified as. They're now classified as level 6 felonies, but in both cases they're the lowest level of felonies. So to expunge the lowest class of felony, level 6 felonies in Indiana, 8 years would have to pass since the date of conviction. You would have to have no criminal charges pending, who have had paid all fines, fees, costs, and restitution, and you also could not have been convicted of another crime within the last 8 years. So that's the basic requirements on how you would expunge a Class D or level 6 felony. It's also important to note with these cases that oftentimes you could qualify for what's known as AMS, or alternative misdemeanor sentencing. A lot of times people qualify for this alternative misdemeanor sentencing but fail to file the paperwork follow-up to actually get the felony reduced to a misdemeanor. So what AMS does is it allows you to file a petition with the court indicating that you completed your sentence or the requirements of the court, and they actually want the court to reduce your felony to a misdemeanor. And that would then allow a level 6 felony or a D felony to be reduced to an A misdemeanor. It's important to see if you have the ability to qualify for AMS. So what happens if you're convicted of a higher level felony? It's typically the same requirements. 8 years passed since your conviction or 3 years passed since completion of sentence, whichever is later. No criminal charges pending, you haven't been convicted of other crimes, you've paid all the costs, fines, restitution. Generally, if you meet those requirements, you should see if you qualify for an expungement of the felony conviction. It's important to know that serious felonies, which are higher than that D or level 6, are granted at the discretion of court. And there's also different waiting periods. For instance, if your felony resulted in a serious bodily injury, they would not be qualified for an expungement. So there's certain areas that you would not qualify for an expungement. It's also important to note with expungement that you're only granted one expungement in your lifetime. So if you do expunge, it's important to get everything wrapped up into that one expungement. So what I went through is a lot, and if you are interested to see if you qualify, you can look in the video in the link below or on my website. I have a test you can take to see if you qualify for an expungement, and it'll walk you through various questions to see if you were eligible. And if you have questions, you could give me a call. I'd be happy to take a look at your record and give you an opinion as to your expungement eligibility. And when it comes to process, every firm may go about expungement differently. We do a much more thorough approach to expungement and record removal than other firms. First step to an expungement is to really gather the paperwork and information. You then file the paperwork in court. And expungement is county specific. So if you have arrest in 2 counties or 3 counties or even 4 counties, you would need to file to expunge the records in each county individually. So it can be an intensive process from a records gathering standpoint and even a filing in court standpoint to go and track down all that information and go to court in each county. The third step is to work through the court process and expunge records. So typically you file, the state would then have a chance to respond to the petition to see if they object to the petition or agree to the petition. And then the court can even set it for a hearing to hear evidence as to why it should grant the expungement. And the fourth step is to actually seal the record, so it's harder to find the negative information about you, and you can start moving on from your past. So that's a high-level overview of expungement in Indiana and how you can qualify for an expungement. It is an option that is readily available if you've been convicted of a crime. One important thing to note is that those time periods I mentioned, they can be moved earlier if the prosecutor agrees. So if you have, for instance, if you're close to the time period and you're applying for a job, the conviction would disqualify you from your job. It may make sense to contact an attorney and see if you can contact the state to see if they would agree to an early expungement. It's also important to see if you've paid all your fines and costs as a result of the case. And that's something we can help you do. We will look to see if you qualify for the expungement and then can represent you through the process. So again, my name's Nathan Vining, an Indiana attorney here. If you have questions, give me a call at the number that follows. Send me a message from my website or take the free eligibility test to see if you qualify.